Welcome to the Health and Care Conversation. Today's focus is subject access requests, data subject access requests that are received from patients and their families. Presenting today, we have myself, I'm a Principal Associate here at Mills & Reeve. We also have Kevin Duce, another Principal Associate who focuses on healthcare, and Katherine Pears, who's an Associate who focuses on data and information law. So the slides will be circulated later, but if you would like to make connections with any of us, here are the QR codes that will let you do so, and the instructions for how you do connect. In terms of what we're covering today, we are covering key terminology in relation to data subject access requests, just to make sure we're on the same page. We're covering what a data subject access request is, or a DSAR, and what you need to think about when you get one. We're covering why patients and their families will lodge them, and who is allowed to lodge them, which can be an issue that's fraught with a bit of difficulty when it comes to the healthcare sector. There are also lots of relevant principles that you need to be borne in mind, not just from data protection law, but more widely from the healthcare sector. Then I'll be covering exemptions to disclosure and examples of how they are applied, and how redactions work in practice. And then we'll leave you with some top tips to take away. So without further ado, I'd like to pass on to Katherine, who will start today.
Thanks, Claire. So before we look at this topic in detail, we always think it's useful to cover some of the key terms in the data protection world, just to make sure that we're all on the same page. For those who have attended before, we promise we won't take too long, but for new attendees, this should help to demystify some of the terms that you'll hear during the next hour. So the first term on the slide is personal data, and that is anything that could identify a living individual. So it needs to be about a living individual, and that person needs to be identifiable. Personal data will include contact details, financial details, photographs, personal calendars, basically anything about a person's family or lifestyle. Essentially, anything about an employee or a patient is likely to be their personal data. You don't need to see a person's name in a document for that person to be sufficiently identifiable from the content of the document. A person is identifiable if they can be properly distinguished from another individual. So, for example, if one of you were to describe me in an email after this training as the associate from Mills & Reeves who delivered data protection training today, you haven't actually used my name, but I'm still identifiable, so it is my personal data. The next key term on the slide is data subjects. They are the individuals who enjoy rights under the UK GDPR, including the right to make a subject access request. Employees, visitors, patients, contractors, these are all types of data subjects. The final key term on the slide is data controllers. The UK GDPR applies to all data controllers, and your organisations are data controllers in every scenario where they determine the purpose and means of processing personal data. In today's training, we're looking from the perspective of a data controller and what it needs to do and think about when it receives a data subject access request, also known as DSARs. Next slide, please. In addition to key terminology, you also need to be aware of the GDPR data protection principles. There are 6 data protection principles under the UK GDPR, which are listed on the slide. These are that data must be processed lawfully, fairly, and in a transparent manner, collected for specific, explicit, and legitimate purposes. Data must be adequate, relevant, and limited to what is necessary. It must be accurate and kept up to date. It must be kept in a form which permits identification for no longer than is necessary. And it must be processed in a manner which ensures appropriate security. There is also an unofficial 7th principle, which is also known as the accountability principle. It essentially requires that you need, in all cases, to be able to demonstrate your compliance. As the data protection principles are important, but when you are processing a DSAR, you need to be aware that when you that the information you disclose may reveal errors in your compliance with the data protection principles. For example, if you disclose data showing excessive collection of data, or that you've held on to data for an unjustifiably long time, you may find that you're met with allegations and complaints of Principle 3 and 4 breaches. If you hold data that has not been kept up to date, perhaps observations, medications, or decisions have changed, but the records aren't complete, then that may result in a Principle 4 issue. Although it is rarer now that we use many electronic systems, but that still does happen. Principle 6, also known as the security principle, is also relevant to DSARs. Many of the basic checks that you will need to carry out, and which can become complex in a patient scenario, are intended to ensure that the wrong people do not get access to data that they shouldn't see. Failure to conduct checks to ascertain the capacity of the requester who is making the request and to apply appropriate redactions to remove exempt material may constitute a data breach. And that's something we talked about in our last healthcare conversation. Data subjects have multiple rights under the UK GDPR. The most significant is often the right of the data subject to access their personal data. This is sometimes referred to as a SAR or a DSAR. Under Article 15 of the UK GDPR, which is set out on the slide, a data subject, for example, a patient, has the right to obtain from a data controller confirmation that their personal data is being processed by your organisation, access to a copy of their personal data, usually free of charge, and access to certain additional details about how their personal data is handled. This additional information is the sort of fairly generic level information you would expect to find in a data controller's privacy notice. According to Recital 63 of the UK GDPR, the intention behind the right to submit a subject access request is to enable a data subject to be aware of and verify the lawfulness of any processing of their personal data. Essentially, the authors of the GDPR recognised that data subjects had a decreasing access to and understanding of what organisations were doing with their personal data, and felt that they had lost or were losing control over what was happening to information about them. The legislation forced the balance back in the other direction. So, what do you actually get under a DSAR? The right is not to be provided with a copy of specific documents, but instead is a right to receive a copy of personal data contained within any of those documents. You're entitled to receive, in a permanent, intelligible format, what personal data is held, how it is being used, who it is being shared with, and where it came from. It seems fairly simple, but as you know, processing a data subject access request can be resource intensive and trigger many questions and issues. They can also be extremely expensive. In 2017, it was reported that the Nursing and Midwifery Council had spent £239,871.85 in legal fees dealing with one single data subject access request. There is also a need to get it right first time. If you don't comply, a requester can either go to the ICO or can complain to the courts to try and force you to do it right. To be clear, a DSAR is not a mechanism to get copy documents. A requester is only entitled to the information under the Data Protection Act, not the document that it is contained within. In practical terms, this may not make much of a difference, but sometimes it does. It is also not a mechanism to get information about somebody else. Information about third parties should generally be redacted. Nor is it a way to get information about deceased individuals. The Data Protection Act only applies to living individuals. Finally, it is also not a way of getting information about something other than a person. Sometimes extra information will be disclosed under a DSAR to provide context and help explain what is supplied, but there are other disclosure regimes, such as the Freedom of Information Act, that can be used to obtain other kinds of data, at least where the data is held by a public authority. So, what should you do when you receive a DSAR? We have set out on this slide the steps you should take immediately. First, you should make sure it actually is a DSAR. You should check whether it should be dealt with and what process it should be dealt with. For example, are they asking for personal data, or is it just information and would be better dealt with under the Freedom of Information Act? Examples of other disclosure requests that are not DSARs include police requests, requests for deceased records, requests from a prison, requests relating to a child made by someone other than a child who is not a parent or guardian, requests from the court, requests from anyone who does not have legal authority to exercise the personal rights of a subject access. So why does proper classification of the request matter? Well, first of all, the timescales for compliance are different. For a DSAR, you generally have to respond within 1 calendar month. But for disclosure under a court order or under a pre-action protocol, for example, access to health records, that is usually 40 days. If it is an actual court order, they are a bit special because of the consequences. Failure to comply with a court order is technically a contempt of court, and contempt of court is punishable by a term of imprisonment. Additionally, there may be cost consequences or other professional consequences. So if you get a court order, don't ignore it. This is a right to apply to vary, but the timescales are usually short, so don't waste the time you have. Police requests can also pose significant problems. Some forces even get data subjects to sign letters of authority permitting the police to make a DSAR on their behalf. Treat such letters with extreme caution, and please be aware that any purported consent by the data subject to the police making a DSAR on their behalf is going to be suspect. It is unlikely to be informed and freely given consent, and we recommend that any disclosure to such a DSAR should only be sent to the data subject themselves. If after consultation with legal advisors and information guardians that you decide to fulfill the request at all. To obtain medical records, the police usually need a warrant or production order. Even where a court order orders disclosure, production should be to the court and not to the police. Now back to DSARs. If you're unsure whether what you have been sent is a DSAR, you need to act and write to the data subject to tell them how you have understood their request and ask them to respond if you have misunderstood anything. In any event, it's good practice to acknowledge receipt of a request. The next thing to consider is that of identification. You need to properly understand who has made the request in what capacity. Consider whether you should ask for ID. If the requester is the data subject acting for themselves, then this can be a simple matter of requesting some formal ID documentation. However, the rule here is that requests to provide proof of ID can only be made if you have reasonable grounds for doubting that the data subject is really the one making the request. We have seen cases of identity fraud where it was not actually possible to determine whether a request was genuine, but that would be very rare. Where a third party with only a limited connection to an organisation submits a DSAR, it is normal to require them to verify their ID and any authorization to show they are permitted to make that request on the data subject's behalf. Complications often arise where the data subject is mentally incapacitated or a child. If you receive a request relating to either of these categories of data subjects, you may need to seek further advice. For patients who are not competent to handle their own affairs, you may be receiving the DSAR from a power of attorney holder, a court-appointed deputy, or a guardian. In such cases, you should ask for proof. If they've been properly appointed, there will be a sealed documentation confirming their role. Ask for the whole document. Lasting power of attorneys can relate to both health and welfare and property and affairs, so you don't want to get it wrong. Thoroughly read what you are sent. People aren't always honest. Be aware that a court-appointed deputy does not have free rein to review everything, and a guardian usually stands in the shoes of the parents, so has a wider scope of access, but still have a think about any potential limits before you provide any disclosure. If something feels off, it probably is. Trust your instincts and dig for more information. When the requester is making the request on behalf of a child, you need to ask who is making the request and whether they have parental responsibility. Modern families can be complex. You're generally looking for a birth mother, a married father, father on the birth certificate, adopted parent, the local authority, or a court order specifying that the requester has the relevant rights. You also need to consider the age of the child. Do they have capacity? Are they GILIC competent? Are they Fraser competent? If these are relevant. If yes to any of those questions, has the child consented to the disclosure? Do they even know about the request? Do you need to alert them to the request and work out whether they are actually happy for their parent to have their personal medical data? And bound up with all of that, how are you going to tactfully handle any rejection of the parent's request, if that is what you intend on doing? parents tend to be extremely upset when they are denied access to their own child's records. As a further initial issue, you need to check your deadlines. You must respond to a DSAR without undue delay and with a month of your receipt of the request. There are always justifications to pause or extend the deadline, but the Information Commissioner's Office is very clear that most DSARs should be responded to and including all disclosures within 1 month limit, unless the request is complex. And finally, DSARs are motive blind. It doesn't matter if there is ongoing litigation and the data subject is using it as a fishing expedition. You have to respond to it unless it is manifestly unfounded or manifestly excessive. Nevertheless, you should always consider what has motivated the requester to put the request in itself. And on that note, I'm going to pass this over to Kevin Duce, who's going to look at what might motivate a patient or their family to submit a DSAR.
Good morning, everyone. Why do patients submit DSARs? It would be an extremely rare scenario for a data subject or their representative to submit data subject access request to an organization with which it has no issues. Although a data subject access request is what is known as purpose blind, which means that no justification is required for its submission, the underlying motivations of the data subject may be useful to know if you can establish what those are. Is the data subject dissatisfied with their treatment? If they feel that their concerns or symptoms are not being taken seriously, then they are more likely to use the DSAR process to try and identify what is happening and what may be the cause of their concerns. Perhaps they wish to seek a second opinion, but have they been finding it difficult to obtain copies of their medical records to allow them to do that? Are they feeling excluded from decision-making or information flows? This may be the case where a patient has come of age and their parents no longer have the necessary authority to know everything that they may previously have been told about their child's treatment. Has something happened that they may want to seek compensation for? So are they starting a so-called fishing expedition for evidence to let them raise complaints? It is a legitimate use of DSAR to try and seek information that would help bringing a complaint or even litigation. The question then arises as to how to comply with the request without placing your organization in an unnecessarily bad position from a litigation perspective. Is a third party for some purpose putting pressure on an individual to submit a DSAR? In many cases, this would not be appropriate, and if you suspect this to be the case, it may be necessary to have conversations with the requester about what is going on in the background. They don't have to tell you, of course. There is a small chance that an individual may simply be curious about what is in their records. Where you can identify both context and motive, you can often use that information to aid you in narrowing down any searches that need to be undertaken and to suggest reasonable limits on disclosure. Responding to a DSAR in a vacuum of knowledge is possible, but with more information, it's possible to do a better job, usually in less time and using fewer resources. Not all requests for information are DSARs. There's a line that has to be drawn between requests for information under the statutory regime and day-to-day requests for updates or general conversations between doctors, patients, and their families, such as a patient asking their doctor for an update on their treatment, an adult with parental responsibility for a child asking for an update on their child's treatment. A patient or parent seeking confirmation about up-and-coming appointments for themselves or their child. A patient asking their GP for a sickness note. A patient asking for a medical report on their condition to assist them, for example, to obtain or renew their driving license. I often deal with the requests for disclosure from third parties, such as the police, the courts, tribunals, local authorities, coroners, and healthcare regulators. Having thought about what is normal in terms of the flow of data to patients and their families, we should now take a quick look at the principles and rules that affect that data flow and which will also affect how you respond to a DSAR. Claire, thank you, Claire. There are 7 golden rules for information sharing in the medical context. These are primarily concerned with the sharing of personal data with someone other than the requester or their representative, but also have relevance to the processing of a DSAR. The golden rules are that you should, 1, remember that the UK General Data Protection Regulation, the Data Protection Act 2018, the human rights laws provide a framework to ensure that personal information about living individuals is shared appropriately. Second, be open and honest with the individual and or their family where appropriate from the outset about why, what, and how, and with whom information will or could be shared, and seek their agreement unless it's unsafe or inappropriate to do so. 3, seek advice from other practitioners or your information governance lead if you are in any doubt about sharing the information requested. 4, where possible, share data with consent, and where possible, respect the wishes of those who do not consent to having their information shared. 5thly, consider safety and well-being. Base your information sharing decisions on considerations for the safety and well-being of the patient and any others who may be affected as a result of sharing the information. 6, data sharing should be necessary, proportionate, relevant, accurate, timely, and secure, and always follow your organization's policy on security for handling personal information. And finally, 7, keep a record of your decision and the reasons for it, whether it is to share information or not. If you decide to share, then record what you have shared, with whom, and for what purpose. In terms of processing a DSAR, you need to ensure that you stick within the legal framework, which includes the application of any relevant exemptions and exceptions, many of which Claire will cover later on in this talk. You need to have open communication with the requester and all the data subject about what you will and will not do when processing a DSAR. Even a third party does have the right to make a request on behalf of the patient. You should still make the patients aware of the request if appropriate, and where possible, respect the patient's wishes about what is being disclosed. Good record keeping is paramount. Make sure you record the parameters of the search for data, what was decided about the result of that search, and what was disclosed to the data subject. This is important should the individual challenge the way in which you have handled the request and what has been provided. If matters are referred to the Information Commissioner's Office for investigation, it will expect you to have a full and accurate record of the DSARs that have been made and how you have dealt with them. Don't forget the Caldecott principles. As you would know, a Caldecott guardian is a senior person responsible for protecting the confidentiality of patients and service users' information, and there to enable appropriate information sharing. Good information sharing is essential for providing safe and effective care. The principles apply to the use of confidential information within health and social care organisations, and where such information is shared with other organisations and between individuals, both for individuals' care and other purposes. Caldecott guardians within organisations should be involved in the handling of a DSAR, not necessarily in the processing of the request, but as a minimum, they will be involved in the final review of data proposed for disclosure. The Caldecott principles are reflective of and work in tandem with the GDPR data protection principles that Katherine took you through earlier. GDPR and Caldecott are only half of the story, though. You also need to consider medical confidentiality, which is perhaps not as sacrosanct as it used to be, but is still hugely important. Confidentiality is an important legal and ethical duty. Parents have a right to expect that their personal information will be held in confidence by their doctors. There will be situations in which certain data is confidential, and although a third party may have the right to request the personal data of the patient, their right does not extend to everything. As Katherine mentioned previously, requests received from third parties must be thoroughly scrutinised. And on that, I'll pass back to Claire.
Thank you, Kevin. So I'm now going to look at the practical steps to take when you're responding to a subject access request. And then I'm going to cover the exemptions that you might be able to engage to withhold personal data, which otherwise would fall to be disclosed. So first of all, you need to narrow the request if possible. Patients may just want a copy of their medical records, but equally they may want to cast a wider net. They may be looking for emails, instant messages, or other materials that relate to them or their ailments. They may suspect that data about themselves is contained within the medical record of another individual. Searching for and handling personal data requested under a DSAR can be extensive, laborious, and time-consuming. So you need to be very clear from the outset as to what it is you're looking for. A data subject is under no duty to agree to narrow the search down, but your search for their personal data needs to be reasonable and proportionate. So if you receive a request that is likely to generate a significant amount of documents, cost a great deal to fulfill, or involve difficult to access or handle data, it would be sensible to write to the requester asking for their help to locate the personal data that they are actually interested in. Usual examples of this are to ask which specific mailboxes, time periods, issues, or themes they are interested in. If you can agree keywords with the requester, this may cut down your work and sometimes significantly. It can be the difference between having to review 30,000 documents and 3,000. Second, you need to know where the personal data is held within your organisation. You only have 1 month to respond to a DSAR, and so it's important to know what your systems are: email, paper files, electronic systems. For a patient, medical records are often computerized, but they may be spread across a variety of systems. If the request is not limited to medical records, so for example, if the patient wants to know about decisions made on personal care budgets, you need to know where any emails, letters, or documents may be located. This can be planned for in advance by undertaking an internal audit to produce a roadmap and a plan of where all the personal data is. Next, consider extending the deadline. This should only be done when a preliminary search has been done. So, well, unless your problem is the technological inaccessibility of the data at all. So it's very important to get on with the search as quickly as humanly possible. In order to extend the deadline, you'll need to argue that the request is complex, and that can provide you with up to an additional 2 months to respond to the request. The ICO has guidance on what it considers to be a complex request, and that includes matters where there are technical issues because the data has been archived, or where there is a need to obtain specialist legal advice. A request that covers healthcare records is a prime candidate for an extension, as it often requires that you obtain legal advice as to how certain aspects of the request can be handled. The ICO has said that requests that just involve a large volume of information may add to the complexity of a request, but a request is not complex just because the individual requests a large amount of information. In other words, you can't have the additional 2-month period just because there's a large number of documents to review. You're expected to locate the resources and the staffing to review them. In any event, it's good practice to get something out to the requester within the original 1-month deadline regardless. This is usually straightforward documents. In the employee context, it's usually the personnel file, but there may be something simple for a patient you can also send. You also need to consider exemptions. There are various exemptions that can be applied to legitimately limit what is provided. You need to allow sufficient time in your process to consider these carefully, and we'll talk through many of those on the next slide. Then, the question is redact or extract. As we've mentioned, a data subject is only entitled to the parts of documents that contain their personal data. It's a right to content, not to copy documents. There are often long email chains where only a small part of the chain actually relates to the data subject. And as a data controller, you have a choice to make as to whether you redact all of the irrelevant data. In practice, this means putting black boxes over the irrelevant parts, or you extract the parts that are relevant into a fresh document and then supply that. You'll appreciate that lots of redactions can often cause more intrigue, as the data subject often believes that the really juicy bit that they wanted to see is underneath one of those black boxes. So think carefully about which approach you want to take. Extraction is also sensible where you have a very large spreadsheet with only one entry relating to the data subject. Good record keeping is extremely important. As has been mentioned previously, you're expected to be accountable for what you do, and you need to be able to demonstrate to the regulator that you followed appropriate processes and made appropriate decisions. You need to make sure that you have proper regard for other people's personal data. Be careful about third-party personal data and build time into your processes to consult third parties about their views on whether and to what extent their personal data may be shared. That relates to the exemptions we're covering next. And the final point I wanted to make in relation to responding to a DSAR is in relation to courts and tribunals. Remember that what people are entitled to in a court case or a tribunal claim is different to what they are entitled to under a DSAR. The court or tribunal rules will dictate what an individual is entitled to receive in each of their respective processes, whereas the GDPR dictates what a data subject is entitled to see under a DSAR. They're different. Having said that, it is important to make sure that you're mindful of both processes. For example, it would be far from ideal if a document was disclosed in response to a DSAR, which was then not disclosed in a tribunal claim when it should have been. That will lead to the requester losing trust in your processes and increases the risk of a further claim or a complaint. So moving on to the exemptions to disclosure. A DSAR may require the disclosure of significant volumes of data, and that content, as we say, can either be supplied by providing original documents with irrelevant and exempt material redacted out, or by extracting relevant personal data into a new document and providing that. The UK data legislation recognises that in some circumstances, you may have a perfectly legitimate reason for withholding data. In particular, the right to obtain a copy of your personal data must not adversely affect the rights of others. So where an exemption applies to the facts of a particular request, a data controller may refuse to provide all or some of the requested information, depending on the circumstances. Where personal data of the requester is withheld from disclosure, you have to be clear as to which exemption applies and inform the requester that you have applied the exemption. there is always a risk that your use of exemptions will be challenged, so it is recommended to keep good notes. So what are the most common exemptions? They're up on the slide. As you'll see, the first two items on the slide list are in square brackets. That's because these are not technically exemptions. They're simply not within scope of the UK GDPR at all. Non-personal data, which is anything that isn't personal data, just isn't covered. It can't be requested under Article 15. It might be appropriate in some cases to include it in order that the data subject can better understand what they receive as disclosure, but it's not compulsory. Third-party data. There is a special exemption for what's called joint third-party data, which I will explain in a moment. However, the data subject is not entitled to receive data that is purely the personal data of someone other than them. That doesn't mean you can never provide it, but to decide whether to hand it over, you need to ask yourself if providing that data would adversely impact the rights and freedoms of the third party. So those are our not actually exemptions. When it comes to actual exemptions, you find these mainly in Schedule 2 to the Data Protection Act 2018. There are also exemptions in Schedule 3, which are about health, social work, education, and child abuse data. And then there are even more exemptions in Schedule 4 to that Act, which concern disclosure prohibited or restricted by legislation. The Schedule 2 exemptions are the ones you might call the normal exemptions. They apply across multiple scenarios and pop up all the time, regardless of sector. So we'll talk through those first before we turn to the healthcare specific ones. So joint third-party data. The joint third-party data exemption is set out in paragraph 16 of the schedule and says that the right to data access does not require a data controller to disclose information to the requester to the extent that doing so would involve disclosing information relating to another individual who can be identified from that information, unless either the other individual has consented to that disclosure to the requester, or it is reasonable to disclose the information to the requester without the consent of the other individual, based on, and I quote, all the relevant circumstances. So it's a balancing test. For this data, which is often found in the form of one person's opinion about another, because that's the personal data of both the individuals, you have to balance carefully all the relevant circumstances. You need to look at a wide variety of factors when making the decision. And according to both Information Commissioner's Office guidance and the relevant case law, you can't apply a blanket policy of withholding the identities of third parties, of other individuals. But instead, you've got to do a detailed assessment of the issue. You may have to contact the individuals to ask whether or not they would consent to the disclosure of their personal data. And if they say yes, that's fine, you have to then send that out, according to ICO guidance. In the healthcare context, there is a statutory assumption that it will be reasonable for the third-party data of health professionals to be disclosed to a data subject, probably a patient, who has made a DSAR, provided that the third-party data appears in a health record. So the names of doctors involved in the patient's care would not ordinarily be redacted out. Given the context, you should also be aware that the names of social workers, children's court officers, and education workers are also likely to be presumed disclosable. Paragraph 19 of the relevant schedule covers confidential conversations with lawyers or others relating to litigation or legal issues. This is the legal professional privilege exemption. The right of subject access doesn't apply to any personal data that is either information in respect of which we could claim legal professional privilege in a court case, or it is information where we owe a duty of confidence, the lawyer owes a duty of confidence to a client. Legal privilege comes in two forms. It's called litigation privilege, which relates to communications about active or pending disputes, and legal advice privilege, which relates to advice, more general advice received from your lawyer. If you want to use this exemption, you do need to be aware that the ICO expects you to be able to state how much of the data you have reviewed was withheld on the basis of each type of legal privilege. You can't just say legal professional privilege. You have to know which ones apply and to what. And you should also be aware that legal privilege does not cover every conversation you have with a lawyer, so simply copying in lawyers, I'm afraid, doesn't help. Instead, the solicitor or barrister in question needs to be approached to give legal advice or actually be giving such advice. And the burden of proving that the data that you have withheld is privileged is on you if the claim is challenged. Moving on, we have the management forecast exemption. The Article 15 right of access doesn't apply to personal data processed for the purposes of management forecasting or management planning in relation to a business or other activity, if disclosure would be likely to prejudice the conduct of that business or activity. In the healthcare context, you might see this apply in the context of patient and social care funding decisions and service reorganisations. Paragraph 23 covers negotiations. Again, Article 15 doesn't apply to any personal data that records the intentions of the controller in relation to any negotiations with a data subject, to the extent that disclosing the information would be likely to prejudice the negotiations. So if you're in settlement negotiations with a patient or their family, perhaps to resolve a complaint or in relation to care provision, you don't have to disclose data that sets out your internal negotiation positions, thinking, and discussions. That would be unfair. You can't be forced to reveal your hand to the other side. Then we have confidential references. Article 15 doesn't apply to personal data consisting of a reference given or to be given in confidence for various purposes, including the provision or prospective provision of a service to the data subject. It would be very rare for this to apply in a patient context, but just know that as a general rule, we always remove confidential references from disclosure. Moving on, we now have the more interesting exemptions from the healthcare perspective. So as mentioned, specific to the healthcare sector, Schedule 3 of the Data Protection Act gives you specific exemptions. If you receive a request for health data for someone with parental responsibility, or someone who's under 18 or 16 in Scotland, or someone who's been appointed by the court to manage the affairs of an individual who can't manage their own affairs, you don't have to disclose the information where, one, doing so would disclose information that the data subject, so probably the patient, provided it with an expectation it would not be disclosed to the requester, or two, the data was obtained as part of an examination or an investigation to which the data subject, so the patient, consented in the expectation that the information would not be disclosed in this way. The only counter to that is if the individual has then later expressly indicated that they no longer have that expectation, they're no longer worried about withholding that information. Another exemption that you need to be aware of is the serious harm exemption, which is at paragraph 5 of Schedule 3. Whether personal data is health data or social care data, and disclosure of it would likely cause serious harm in the opinion of the appropriate medical professional to the physical or mental health of either the data subject patient or another individual, it can be withheld from disclosure. In order to rely on the exemption, the assessment of whether serious harm may be caused must be carried out by a health professional. It can't be done by your team of data protection professionals. It's a medical decision. It's a very serious and very important exemption because getting it wrong clearly can have serious repercussions. Release of data that should have been withheld can result in very unhappy patients and third parties, with all the attendant litigation risk there. But refusing to disclose it may result in the Information Commissioner getting involved. So it's a difficult line to tread. But we do recommend that you err on the side of caution. If you do wrongly withhold data, the ICO is most likely to simply say, we don't agree, you should disclose it. In contrast, wrongful disclosure is a genie that will not go back into the bottle. Finally, paragraph 21.3 of the Schedule 3 provides an exemption that relates to child abuse data. If you receive a request from someone with parental responsibility for an individual aged under 18, or someone appointed by the court to manage the affairs of someone else, you don't have to release any child abuse data to the extent that complying with that request would not be in the best interests of the individual who the child abuse data is about. And so child abuse data is personal data consisting of information as to whether the data subject is or has been the subject of or is at risk of child abuse, so neglect, physical or emotional treatment, etc. So those are the exemptions, but how do we deal with it in practice? Here's some clearly made up examples for illustrative purposes only, and it is a very, very rough guide. Looking at the first paragraph on the slide, things to think about here would be that the sentence about Peter's father could be irrelevant. It could be joint third-party data, but importantly in context, it could also be part of or hint at child abuse data. So you might want to redact it. The name of the doctor is presumed to be disclosable, and that seems fine here. Mentions of abuse may need to be removed. You'd need to consider who made the request, why, what authority they had, and whether the data poses risk of harm to anyone. And the sentence about a diagnosis of a blood clotting issue seems fairly harmless and unlikely to be an issue. Looking at the second paragraph, all about contraception, things to think about for this would be, if this was a DSAR received from a parent, what are the individual's expectations and wishes? Even if it was not clear that they really don't want the parent to know, would you need to go and ask them for their position anyway? Again, the name of the practitioner could be disclosed without issue, but it'll likely be redacted here as the rest of the sentence is likely protected. And looking at the third paragraph, here this is mostly harmless, but the reference to the sister is superfluous and it is not the personal data of Laura. If the DSAR is focused on Laura's personal data, the reference can be redacted. So what might that look like? Oh, like this. This is one potential outcome, but as I say, it's a rough guide, and it will, as I keep hinting, be very context dependent. As a point on redaction, this should be done with specialist redaction software. Black marker pen can be seen through if you hold documents up to the light. And if you apply black boxes in Adobe, in some cases, a person can just select all text, copy and paste it into a Word document, and they'll be able to see what's underneath your boxes. So this brings us to the breach risk during disclosure. So you've collected your data, you've reviewed it, you've tagged it, you've extracted or redacted it where appropriate. You've kept the records as to everything you just did, and that's perfect. But now it's time to disclose data to your requester. And this is a critical point because it's a point where everything can go very wrong. It's vital to ensure you are delivering the disclosure to the requester in a very secure way. Sending things through the post is not a good option. Even through courier isn't great. The post is a mere processor and is not liable if they lose the disclosure. The best way to send disclosure is via an electronic share file, which requires the requester to log in and download the items for themselves. So you upload the documents to the folder, you tell the requester they have a specific length of time to download it, and you give them a password. It's also best to send the password via a different means of communication. So don't send the link and then the password, or both via email. It's best to send one via email and say one via text. If the requester does want you to send things in hard copy, make sure it's via sign for delivery, or that the requester is required, if reasonable, to come and collect it. So if they only live a mile down the road, they can come and get it from you. So key points. We're coming to the end of the slide, and in a moment we're going to check the Q&A. But first, to reiterate the key messages from today, DSAR processing does require you to understand not only the data protection principles, but the golden rules for data sharing, the Caldecott principles, and of course, keep in mind your duties of confidentiality. Not all requests you get will be a DSAR. Make sure you properly understand the nature of the request. It's a lot easier to deal with a general inquiry than it is to deal with a DSAR. Check carefully whether the requester has the ability to make the request. This is absolutely crucial, and it does often get overlooked. Even if someone appears to have the ability to make a request on someone else's behalf, check, and double check. And be clear on the exemptions and make sure that they are applied where it's appropriate to do so. And finally, at all times, keep an eye on risk. So thank you for attending today. We hope this has been very helpful for you. And now we will look for questions. There we go. Right. So we have one question on the 1 month deadline beginning from the ID validation. Yes, you are correct. 1 month deadline starts as soon as you validated the ID. The only issue that you may have is that you shouldn't be asking for ID if you already essentially know who the person is. So we've seen quite a lot of data controllers who, despite the fact that they know the person, they know they have capacity, they are in no doubt as to the identity of the requester, they go and ask for ID anyway. That's not a valid request for ID. So your time may start already and you may miss your deadline if you don't just get on with it. If we have a question of, if the data subjects request us to provide all their personal data which we're holding in our system, shall we also provide any emails in which the requester can be identified but they were not the sender or recipient? Yeah, they are entitled to any data that is about them, whether or not they have seen it previously. If you have emails in which they are talked about, but they have not seen them before, you would need, that's when you would need to start considering the exemptions and consider whether it's appropriate for them to see that information. But the right is to any data about you, which is anything that's of biographical significance, relates to you, used to make decisions about you, things like that. Okay, we've been through the exemptions. As I say, the slides for this session and the recording will be provided to you. So if you want to listen through the exemptions again, you are most welcome to do so. Or if you have any unusual scenarios and you want to actually get in touch, you will have our contact details to enable you to do so. Yeah, we've got a comment as well saying, just on the point about wishes of the data subject not to share for health records, this wish does continue to be relevant even for the deceased, and that is correct. Access to the records of the deceased are done under the Access to Health Records Act. It's nothing to do with the GDPR. From the GDPR's perspective, once the patient is deceased, the GDPR isn't that bothered about getting involved. It's a completely separate regime, but you do still have to be mindful about what that individual wanted other people to know. So if you did receive information and were told, don't ever tell my family about this, it's not something you hand out even when they're dead. Okay, we've got a point about the Caldecott Guardian and whether or not they can review your requests. You have quite a lot of requests every year. Yeah, in which case, if you do have that situation and you have so many requests, the Caldecott Guardian frankly couldn't get involved in all of them. All we would recommend in that case is, as well as training up your data team significantly, would also be just to have a triage system in place to try and ensure that the Caldecott Guardian does see the requests most likely to cause you issues. Okay, we've got one question of, if you withhold records under the exemption of serious harm, what do you tell the requester as to why this has been redacted or withheld? This will depend on what you think might trigger the problem. So in some cases, we have seen patients who have mental difficulties, who we can actually tell them we are invoking this exemption because we think this will trigger a response for you that would not be welcome and would hinder, it would not be in your best interests. In those cases, you can, of course, tell them which exemption. If actually telling them that you are using this exemption will be enough to cause the serious harm, clearly you don't tell them, you gloss over it. And then that is something that you can always explain to the regulator if they go to the regulator at a later date. Regarding the serious harm test, if the consultant is of the opinion that part of the record can be provided but not all, is this okay? Yes. The exemptions, you have to take each bit of data separately. So it's usually the ideal to break it down into chunks and work out for each bit, is there a problem disclosing this bit? So if you are looking at the serious harm test and half the record is fine to disclose and half of it is very much not fine to disclose, you just redact out that half that we're not disclosing if your consultant has said, no, don't give them this. That's not a problem at all. Okay, we have got the question on what is the panel's thought on shared records, where a single controller is actually holding records from others. So how does this fit with a DSAR? Right, as a controller, you need to understand whether you are holding records as a controller or a processor. As an organization, sorry, you have to understand if you're a controller or processor. The subject access right relates to any documents you are holding as controller. So anything that you have received from a third party, if you have received it, taken it into your systems, and you then determine the purposes for which it is processed and how it is processed without having to get the permission of the person who gave it to you, then it's within scope of the subject access request. So it is potentially going to be disclosable. If, on the other hand, you are holding it as a processor on behalf of the other person and you only process it, do what they tell you to do with it, any request for access to that information should go to that other organization that you are acting as processor for. You would not disclose that. You would kick off the request to the other organization and get them to deal with it. Okay, we've got quite a long comment about records for the police. Releasing records to the police. That's actually quite a complicated scenario, so I'm not going to deal with it right now, but we will get back to you in writing on that one. Oh, hang on. Okay, and where you, sorry, I've got a supplemental question of where they are operating as joint controllers. So in that scenario that we had, where you have got documents from another organization, you're holding them, but you're holding them as joint controller. Together you are joint controller. Whoever receives the subject access request has to answer it. But as joint controllers, you should have some sort of protocol in place for how you are going to deal with that. And at the simplest level, it would be if we receive a request for data that we are holding jointly, we will consult together in order to determine whether or not exemptions apply. But the overall responsibility for making a response and for sending out information is on the one that received the request. And the other joint controller can't, if you think that you need to hand out the information under the subject access request, if you cannot identify an appropriate exemption, even if the other controller is not particularly happy, you still need to hand it out. But think very carefully about your exemptions because there's quite often an ability to apply one.